Our next case is in re Chastain. I'll note that Justice Allen is recused in this case. We'll hear from the appellant.
Good morning, Mr. Chief Justice, and may it please the Court. My name is Matt Ballou, and I represent the appellant, Ms. Chastain, who's seated behind me. I would like to reserve 5 minutes for rebuttal. I have two overall points that I'd like to make with the Court this morning, and if I may briefly summarize both of them. First, we ask that this Court vacate the April 2022 order on appeal because the trial court lacked subject matter jurisdiction to issue an Article 6 disqualification order. The Court of Appeals opinion in Chastain 1 sua sponte directed the trial court to issue an Article 6 decision, but as we know, an appellate court cannot create or manufacture subject matter jurisdiction where none otherwise exists. Accordingly, the trial court and then the Court of Appeals in Chastain 2, and now presently this Court, are without subject matter jurisdiction to weigh in on the merits of that Article 6 decision. And so it must be vacated. In so doing, this Court is not required to announce or to carve out the contours of what corruption or malpractice means under Article 6 in its decision. By vacating, it ends this appeal and it ends this case. Second, and in the alternative, should this court find that jurisdiction did exist, this court should reverse the trial court's order and the Court of Appeals majority opinion below, because Ms. Chastain's actions at issue in these 4 separate incidents, though regrettable at times, do not rise to the constitutional dimension required for an Article 6 permanent disqualification from any elected office in this state. In the limited number of prior cases in which this court has deemed disqualification of a judicial officer appropriate, that result is reserved for only the most extraordinary, egregious, criminal, and morally corrupt cases. Article 6 permanent disqualification is akin to a civil death penalty of sorts, as it strips a citizen of their very citizenship rights. It is for good public policy that that standard must remain very high and rarely apply. The trial court and the Court of Appeals majority below improperly diluted that extraordinary constitutional standard, bringing potentially dangerous statewide consequences. So if I may, I'd like to address now in more detail why the trial court lacked subject matter jurisdiction to issue the order that is on appeal. Your Honors, this case began as an Article 4 removal case of a clerk of superior court from her remaining term of office. It has since become completely disconnected from its procedural moorings and has morphed into an Article 6 permanent disqualification decision. But in order to understand this, it's helpful to go back to how this entire procedure started. It was with the filing of a July 2020 charging affidavit, as we term it in the briefs. This affidavit cited solely one statutory basis to invoke the subject matter jurisdiction of the trial court. That was Statute 7A-105. In fact, that statute is cited in the caption of the affidavit itself. 7A-105 is a statute that the General Assembly enacted to provide jurisdiction to a trial court and a process to remove a clerk from her remaining term of office. Notably, it says nothing about permanent removal, nor does it ever mention disqualification under Article 6. Both 7A-105 and Article 4, for which it breathes procedural life, make expressly clear that only one judge may preside over a removal hearing and enter the removal decision under either branch, Article 4 or 7A105. And of course, that is the senior resident Superior Court judge in the district. In this case, it was Judge Dunlow. That did not happen here. A separate independent Superior Court judge ruled that Judge Dunlow was disqualified from presiding over the removal hearing due to conflicts.
Who made the motion?
Ms. Chastain's trial counsel made the motion, Your Honor.
Did the trial counsel concede that if Judge Dunlow couldn't hear the case, it couldn't move forward?
I do not believe so, and I'll have to revisit the record during my colleague's time and argument to give the court a better answer, but I do not believe so.
Do you agree with the Court of Appeals that the rule of necessity would have enabled Judge Dunlow to have heard this case?
I personally do not believe the rule of necessity works that way in this context. However,
So are you saying that under the Constitution and the statute that no one could hear this case?
I personally believe that that presents a new issue that is very difficult for this court to grapple with. However, the court does not have to answer that question respectfully, because if the rule of necessity did apply that way, then of course what that means is that Judge Dunlow should have presided over the removal hearing. He should have been the judge to enter the order despite the disqualification.
Well,
that did not occur.
If the court were to accept some of your arguments, wouldn't that be a remedy to send it back to the trial court and instruct Judge Dunlow to hear this matter pursuant to the Constitution and the statute?
It would not, Your Honor, and the reason why is because that has been rendered moot. The only available remedy under 7A105 or under Article 4 is removal of the clerk from her remaining term of office. Ms. Chastain was suspended. Her term was set to end in 2022. That time has come and gone. A remand to the trial court now for Judge Dunlow to redo these proceedings is moot because the only remedy available cannot be issued. It's already come and gone. A new clerk was elected. We cannot turn back the dial, so to speak. It has been rendered moot.
I have
Yes, ma'am.
a different question, or on the same topic of the Court of Appeals ruling in Chastain 1 that Judge Locke could not be under Article 4, the judge who rules in this case. And I guess my question is, isn't the whole theory behind when a judge is appointed to take the place of a judge who's recused, that he, in a sense, steps into the shoes of that judge? And so isn't it possible that our court could conclude that under the Constitution and under this very specific provision which exists to deal with this circumstances, that is to say a clerk of court and removal of a clerk, that if there is a recusal, the judge who's appointed is, for the purposes of that proceeding, the senior resident Superior Court judge, because he is stepping into the shoes of the judge who's been recused?
I agree with Your Honor that that is, in general, what happens when a judge is appointed to preside after a recusal or a disqualification such as this. However, the point in which I disagree respectfully with Your Honor is that I do not believe that this court or any court can override or change the clear terms of the Constitution. And the Constitution under Article 4 expressly requires the senior resident Superior Court judge. The reason why, however, this court does not have to address that issue here in this case is because of the mootness point.
But let me say the reason why I think we do have to address it, and that is because if we allow that precedent from the Court of Appeals to stand, then it would seem that any time a clerk is, an affidavit is filed, any time this type of proceeding happens, and of course we hope it doesn't happen very frequently, but we have to accept that it might happen again. And if it were to happen again, it is certainly very common that either the senior resident Superior Court judge has personal knowledge of facts, could be a witness, is involved in the incident, and essentially by saying that the recusal does not allow someone to step into the shoes and be the senior resident Superior Court judge for these purposes. It means that you can never have a proceeding under Article 4 if there's any basis whatsoever to suggest recusal.
Right.
And it seems to render that a constitutional provision inoperative, which would not be what we should allow to stand.
I totally understand the court's point, and this is a difficult question to grapple with. However, if the court finds that the rule of necessity does apply to this situation, and the court would like to announce that in its decision.
But I'm actually not saying rule of necessity.
Yes.
I think I'm saying that under the provisions that we have that allow for recusal and appointment of another judge, that in effect, what has happened is the other judge becomes the senior resident for the purposes of this proceeding.
I see. I believe, Your Honor, that the court cannot override clear and unambiguous language required by the Constitution. This is language that the people have required. The people have stated that only the senior resident Superior Court judge can preside over that removal decision. Had Judge Dunlow done that in this case, or had Judge Locke done that in this case, the end result is the same. We reach the same point. Ms. Chastain's chance to finish out her remaining term has been eliminated. That issue has been rendered moot.
We have some guidance from the governor's pardon and clemency power, right? Because suppose the governor said, oh boy, I've got a real conflict of interest here with these folks that are asking for clemency. Maybe I prosecuted them or what have you. Can anyone else step into the shoes of the governor and pardon those people or grant the clemency?
Happy to admit I'm not an expert on that area of the law, Your Honor. I cannot answer that question for the court. However,
I think the answer is no.
yes.
Okay.
I was getting ready to say I don't think so, but I cannot cite the court any authority to support that. However, if the result of this law, as the court finds it, is that the Constitution is clear, it could only have been Judge Dunlow, the rule of necessity could not, or excuse me, that Judge Locke lacked jurisdiction because he is not Judge Dunlow, that does make some good public policy sense when one considers, Justice Earls, that it will often be the case that if removal proceedings are sought of a clerk of court, which are very, very serious matters, overturning the will of the people that voted the clerk into office, that is a very, very serious matter. When that is sought, if the senior Superior Court judge is too entangled with the facts upon which the removal is sought, it is good public policy to say, on these facts, you cannot use this route. There are other routes. There are other mechanisms. If removal or disqualification is sought, criminal prosecution, impeachment, there are other mechanisms. But if the judge is too entangled to be disqualified under the codes of judicial conduct, the rules of professional conduct, to consider the case, then it may well serve a good public policy for that decision not to be made on those facts. On those facts, Your Honor.
Counsel, wouldn't the Constitution trump the rules from judicial standards?
Yes. Yes, I agree with Your Honor. And that is why the language of Article 4, as well as 7A-105, which the General Assembly passed to breathe jurisdictional life to Article 4 for clerks, it is clear and unambiguous. It is clear and unambiguous, and I believe it does trump in that case. But of course, the end result, as I have said, remains the same.
So
All
I
that
wanted
could
to ask
happen.
you
Yes,
one
sir.
quick thing when you were taking out that list. So you acknowledge that the General Assembly could have impeached your client if, for example, the senior resident Superior Court judge or others went and said, although I could invoke the rule of necessity, I cannot in good conscience sit on this case, and therefore I'm unable to carry out what the Constitution anticipated, but you can. Do you acknowledge that that's a possibility?
I have researched that issue. My reading of the impeachment rules, both in the Constitution and otherwise, is that it appears that impeachment may be limited to only certain types of elected officials, such as council of state and judges. However, I can't find a limitation that it can't be used against any elected official. But even if impeachment wasn't available because such a limitation existed, criminal prosecution for a felony would result in the removal because it would result in permanent disqualification under Article 6, which
So
is
that
what
was
was
something else. You seem to, there's an implication here that I'm curious about. So you agree with the holding in Chastain 1 that permanent removal and disqualification from office are synonymous? So if you are, the provision in our state constitution that says suffrage or eligibility to office and then discusses disqualification, you think someone disqualified under that criteria is by operation of law also removed from office?
No, I do not agree that removal from that particular office equates to disqualification to all elected officers.
Well, but I'm asking the reverse.
Oh, I'm sorry.
If you are adjudged disqualified
I see.
from the office you are currently holding, is that a disqualification for you to run for that office again? Or is, in your view, that also by operation of law, if you are in that office currently, you are kicked out? What's your view of that?
If the disqualification decision is an Article 6 disqualification, then it doesn't matter if the order says permanently removed from just that office. You have been adjudged guilty of corruption or malpractice under Article 6, and the text of that part of the Constitution is clear. That
Well, I guess
citizen
my
is
question
disqualified
about that,
from
though,
all
this is-
elected office.
This is what troubles me about that. I mean, if you're conceding this, that that provision is not just limited to a clerk of superior court or some other local official. The governor of North Carolina could also be disqualified from office under that provision.
Absolutely.
But in the Constitution, it is very clear that the only way you can remove the governor from office is impeachment. But under the theory you just articulated, some litigant in some rural county could get in front of a judge, get an order adjudging Roy Cooper guilty of malpractice in office, and then order him to pack up his things and leave the governor's mansion. And that seems like it can't possibly be what that provision means.
I totally understand, and that's one of the biggest problems with this case and how it has reached this court. I want to be clear. It is our position, and I think this is clearly supported by the text of Article 6, that if this court were to affirm the trial court's order, that does mean tomorrow anyone could walk into a courthouse, clock in an affidavit that says, I believe this person has committed corruption or malpractice in office. In no less than 10 days, that person, whether it's the governor or all the way down to a mayor or sheriff, would be subjected to a trial with witnesses, documents, evidence, with no right of discovery beforehand, and through the signature of a judge's pen, could be found to be guilty of corruption or malpractice under Article 6, and therefore permanently disqualified by the clear text of Article 6 from holding any elected office ever again in this state, and likely, Your Honor, that would be true in other states that have similar provisions to ours to say if it happened in this state, it's going to apply here too. That is why in my opening remarks I described it as akin to a civil death penalty. And yes, we do believe those are the
Isn't
implications.
your strongest argument then that just like the governor, your client cannot be removed from office using Article 6?
That is
Your
correct.
client could be prohibited from filing for election to that office again because you're now disqualified based on a judgment entered by the court. And if that's the case, then your client was not properly removed from office because this was not either the statutory or the Article 4 criteria to do removal. This was a proceeding that occurred under an inapplicable part of the Constitution, right?
That is correct. And if I may explain and elaborate as to why. Yes, Your Honor, that is exactly our position. The trial court had no subject matter jurisdiction to issue an Article 6 decision. The court had no power to weigh in on the merits of whether Article 6 corruption or malpractice applied because the General Assembly to date has chosen not to pass any statute providing such jurisdiction to the trial court or providing any process for the trial court to conduct that type of hearing. The only time that has happened to date is in connection with the 1971 amendment to Article 6, where I'm sure this court is aware, it used to read for over 100 years, convicted of corruption or malpractice. And in 1971, that was amended to say adjudged guilty of corruption or malpractice. And this, at the same time, the Judicial Standards Act was passed, because there was a need for sitting judges to have a different method of being disqualified rather than relying on local district attorneys to criminally prosecute them, which is very difficult and rare for obvious reasons. This is all
Well,
explained by, yes, sir.
We dealt with that in Ray's Peoples, the 1978 case.
Yes,
Where, on the one hand, we noted the availability of Article 4, Section 17.2, but then we went on to say that under Article 6, there was the authority to remove, and we called it actually an alternative ground. So do we overturn, under your theory, in Ray Peoples, or how would you distinguish it?
no, Your Honor. In fact, our position today relies on Peoples and is totally consistent with Peoples, and Peoples is very important.
But you're arguing subject matter jurisdiction.
Yes, sir.
The court clearly held it had subject matter jurisdiction over Judge Peoples under
Yes.
Article 6. So how is that consistent with your subject matter jurisdiction argument?
Because this court in Peoples, in rejecting Judge Peoples' argument that no subject matter jurisdiction existed, stated the following in its holding, quote, "We conclude that the substitution of the term adjudged guilty for the term convicted permits the General Assembly to prescribe proceedings in addition to criminal trials in which an adjudication of guilt will result in disqualifications from office."
Am I remembering something wrong? Didn't the judge in Peoples resign before the?
Yes.
So isn't the point that the holding that we had in Peoples was, of course, judicial standards, there was no way to remove that judge from office. The judge chose to step away from the office before you could get there. So the penalty that they imposed was the Article 6 penalty of, we're going to disqualify you from office, you're never coming back. So there's nothing in Peoples that is inconsistent with the idea that you can't use Article 6 to remove someone from office because the judge in Peoples was already chose to remove himself, right?
I believe I understand your question, and I believe I agree with it. However, to wrap back around to this core, critically important point about subject matter jurisdiction, I read the holding in Peoples, and there's another case I'd like to bring up in Ray Spivey, but I read the holding in Peoples to specifically state that the reason why this was a constitutional result and it did not violate Judge Peoples' constitutional rights to disqualify him using Article 6 is specifically because the General Assembly had chosen to create the Judicial Standards Act that provided jurisdiction through this administrative process to be reviewed by this court to render an Article 6 result. Without that, there would be no jurisdiction. If I may bring up In Re Spivey briefly. In Re Spivey is a district attorney removal case. Why is that relevant here? Well, there is a statute that the General Assembly has passed for the removal of district attorneys, 7A-66. Interestingly, our Constitution is silent about removal of DAs, where it does talk about that for other types of judicial officials. And in the Spivey case, the district attorney challenged the subject matter jurisdiction of the trial court to remove him, saying, you can't do this, the Constitution doesn't provide for it. And this court, in Spivey, rejected that argument and said the trial court did have subject matter jurisdiction because the General Assembly chose to pass a statute to provide for that jurisdiction in that process. And if that process is followed, it does afford that district attorney due process of law, so the district attorney could be removed. The key here is that the General Assembly knows how to do this. They passed such a statute for judges to have Article 6 decisions be made through this procedural process. They have passed a statute for clerks to just simply be removed under Article 4. They have passed a statute for district attorneys to be removed. They have passed a statute for magistrates to be removed. What they have chosen not to do to date is pass a statute that allows for a civil superior court to issue an Article 6 disqualification decision, the highest there is under our Constitution, for clerks or any other judicial officer besides a judge. And therefore, the order below must be vacated for lack of subject matter jurisdiction.
This is the part of your argument that I struggle with the most, though, because even if there was no enabling statute, there must be some way in the law that you can carry out the commandment in Article 6 of the Constitution. And we do have that, right? We've acknowledged in cases like quorum that we will provide some mechanism through the common law, even if the legislature doesn't provide one. So there's either an enabling statute that allows you to have someone judged guilty of these things, or you can just, the courts will create it for you. So, I mean, the fight over could your client be disqualified from office, I think there's a jurisdiction for that. There must be somehow. But what I'm getting at is what happened in this case is your client was removed from office. And I'm trying to figure out if the way that this was done was constitutional, because it didn't seem to operate under the provision of the Constitution.
Correct.
That allows your client to be removed.
That is correct. If I may comment on quorum, I too considered that, Your Honor. And my understanding of quorum and its progeny is that it applies differently in a different context. If you have, for example, a plaintiff who has been injured and has a claim for some type of damages, money damages, other types of damages, and there is no statutory remedy or administrative remedy available, then quorum will fill in that gap. The holding and quorum will fill in that gap and say, you are allowed to file a lawsuit and allege your injury, and the basis for that to confer jurisdiction will be your constitutional right that you've suffered a constitutional injury. My contention is that is just completely an opposite of what we have here. There is no comparison here. Other times that this court has considered this issue, the court has looked to whether there is a statute conferring jurisdiction. And this doesn't render Article 6 powerless. It doesn't render it toothless, so to speak. If a clerk or a DA's or a magistrate's conduct is bad enough to warrant disqualification, a criminal prosecution has been the method that the trial courts can use for a felony charge for over 100 years in our state. Nothing has changed about that. It can still be done. Elected officials such as judges or counsel of state can be impeached. The Article 6 standard lives in the same text as words like treason, guilty of corruption or malpractice, being adjudged guilty. This court said in Peoples that just because the General Assembly changed it to no longer say conviction, guilt still means something in this statute. It connotes, quote, evil, intentional wrongdoing, where the actor is conscious of culpable acts. It is reserved for the highest of the high. That is why, if the trial court has not been granted jurisdiction in a procedure to do this, that means the General Assembly has chosen not to do that as of this time, and this court cannot, with all due respect, this court cannot do that for them. The General Assembly has to create that jurisdiction. I do want to mention that if the court finds that subject matter jurisdiction existed for Judge Locke to enter the April 2022 order, which is the one that's on appeal, the first order has been vacated. If the court finds that jurisdiction existed, we ask the court to reverse on the merits, because Ms. Chastain's conduct, as I mentioned in my opening, while regrettable at times, while the court may find amounted to errors in judgment at times, mistakes, things she should not have done or things that she should not have said, they cannot and must not be equated to this highest standard under Article 6. And if the court simply compares the prior cases in which this court has found disqualification from judicial office has been warranted, the contrast between Ms. Chastain's conduct and those cases could not be any more stark. If I may, before my first amount of time is over, just mention a few of those cases.
Counsel, this is all the time you got left.
Yes, sir. If I may mention just a few of those cases. N. Ray Kivett, having sex with a juror, what amounts in my mind to rape of a juror while ordering a bailiff to guard the door during a trial. Sexually assaulting probation officer to the extent where she has to physically fight him off. Being found involved in illegal drug smuggling activity and asking another sitting judge to undo the grand jury investigation against him. N. Ray Peoples, the Judge Peoples file, the infamous Judge Peoples file. These cases show you over and over again that it is intentional, criminal, morally corrupt. Often the judge went to federal prison For tax evasion or drug charges, they stand so separate and apart from Ms. Chastain that it will establish dangerous consequences if this court were to affirm on the merits, because this could apply to any elected official under Article 6. With the 20 seconds I have remaining, if there are no further questions, thank you.
Thank you, counsel. Hear from the appellee.
Mr. Chief Justice, and may it please the court, my name is Kip Nelson, here with Boyd Sturgis and Beth Shear on behalf of the affiant, Jeffrey Thompson. Your Honors, there are several bases to affirm the trial court's order, as alluded to through this questioning, but the most simple and straightforward is under statute section 7A-105, the statute that everyone proceeded under in the proceedings below. The parties, the judge, that was what everyone understood to be in play. Under basic principles of constitutional avoidance, this court doesn't need to reach the questions of what do the words corruption or malpractice mean, or how could someone be disqualified under Article 6 of the Constitution. The court has a more straightforward route under section 7A-105 and Article 4 of the Constitution.
But can't we do that only if we accept the reasoning that you heard articulated by Justice Earls and say that it didn't have to be Judge Dunlop?
That is the one issue that was raised by the Court of Appeals. So, yes, so if we're in Article 4, the standard is misconduct. Not even the dissenting judge said there wasn't misconduct, so I think that's an easy affirmance. The question, as you raised, Justice Dietz, is who could make that determination? There are several problems with the approach taken by the Court of Appeals. The first being, Ms. Chastain never raised this issue. Under basic principles of the party presentation doctrine, we expect litigants to raise the appropriate arguments. She never raised this issue in the trial court or even on appeal. This issue only came out of the Court of Appeals in Chastain 1. And secondly, this was not an inadvertent mistake that somehow she had forgotten. This was an intentional waiver. She filed a verified motion to recuse the senior resident superior court judge. There was a separate evidentiary hearing on that issue. An out-of-county judge was brought in to decide that very issue. So this was not mistake, nobody was aware, this was an intentional act on her part. The third reason is the plain text of the Constitution does not require the senior resident superior court judge to hear the matter. There are provisions in the Constitution that use words like shall or only and seem to limit who can decide a matter. This, in Article 4, it says any clerk may be removed by the senior resident superior court judge. Of course, that constitutional provision should be interpreted in conjunction with other provisions. Specifically, as I believe Justice Earls was alluding to, one provision gives the Chief Justice of this court the power to assign judges in the superior court. That's what happened here. After Ms. Chastain demanded that the senior resident superior court judge be recused, the Chief Justice of this court assigned Judge Locke to preside over the matter. We've never heard an argument, ever, on why that assignment order was improper or invalid. So yes, Justice Earls, to your question earlier, he was in fact assigned by this court to stand in the place of the senior resident superior court judge. That's what happened. Again, nobody challenged that, nobody raised this issue. And finally, on this point, this interpretation of the Constitution doesn't make sense as a practical matter. The Constitution envisions that the senior resident superior court judge will preside over a removal hearing because that individual is probably the most familiar with the clerk of court and would therefore be the most appropriate to hear that matter. But there are situations where that person would not be appropriate to hear that matter. For example, if the senior resident superior court judge is the one making the accusation against the clerk of court, it wouldn't make sense for that individual to preside over the hearing. Or if the allegation is that the clerk and the senior resident superior court judge are in cahoots and have engaged in misconduct together, again, it wouldn't make sense for the senior resident superior court judge to hear the issue under those circumstances, which is why judges are routinely assigned. The same thing applies to district attorneys. So under the Constitution, a district attorney is given constitutional jurisdiction to prosecute crimes within a certain district. And yet that doesn't always happen. There are circumstances where a particular district attorney cannot hear a matter, and so it's assigned to a district attorney from somewhere else. Again, that's what happened here at Ms. Chastain's request, and assuming that Judge Locke had the authority, we would ask that this court affirm the original order from Judge Locke that proceeded under Section 7A-105 and Article 4.
And can I just ask another question about the potential consequences of not reversing the Court of Appeals on this point about whether or not Judge Locke could rule under Article 4? And that is, we heard from your colleague that it's okay if there's no, if no one can bring an Article 4 proceeding because there's criminal process. But isn't there a really important distinction between the grounds for removal versus the grounds for disqualification? And that removal can happen for misconduct. It just says misconduct, doesn't say willful misconduct, it says misconduct. And it also says I think there's also mental or physical incapacity. Well, you can't be disqualified for mental or physical incapacity. So there's a real difference, and certainly you're not criminally liable for mental or physical incapacity. So isn't there a pretty significant difference in the standards that apply, and that if we don't have the Article 4 removal avenue, we've lost something that the Constitution is trying to provide?
Yes, Justice Earls, that's exactly right. I mean, ignoring Article 4, Section 17 in favor of Article 6 would make Article 4 superfluous, which of course this court won't do, right? All of the provisions of the Constitution have import and effect. And as I understood my friend's argument in response to the Chief's question, there's nobody who could hear a matter under Article 4 if there's some sort of conflict or potential conflict. That can't be right. I mean, we instituted this provision under the Constitution for this purpose, specifically that a clerk of court can be removed under certain circumstances. Section 7A-105 was the General Assembly's implementation of a procedure for how that happens, just as it has done with other offices, as Mr. Ballou alluded to.
Is there any significance between the difference in the language in Article 4 versus language in Article 6, in which one says removed from office, which seems to contemplate a currently existing right or occupant, versus disqualified for, which seems to be prospective?
So I agree with you, Justice Berger, that the wording is important, and Article 6 answers a who question. Who has been ineligible, deemed ineligible to serve in an office? And there's a list, one of which is someone who has been adjudged guilty of corruption or malpractice in any office. That is a who question. The how you get there question is answered by statute, such as Section 7A-105. There is a difference between removal from a particular office and disqualification from serving in any office. So if you are disqualified under Article 6, that's certainly a more severe sanction than removal from a particular office under Article 4. So in that sense, Article 6 is more severe. But I would disagree just slightly with your premise, which is Article 4 and the statute both talk about removal, not necessarily removal during this term. In fact, everyone agreed all along in this case that removal meant permanent removal from a specific office. That was, if you look in the record, Ms. Chastain's motion to sequester witnesses, she specifically said that. Even in the brief to this court on page 3, the assertion by Ms. Chastain was that the proceeding was permanent removal from the office.
But that's the in re people's issue, which is the reverse of what happened in this case, because what we're looking at is not the use, whether under Article 4 being removed is going to also preclude you from ever trying to run again and obtain that same office again. We're looking at the provision in a part of the Constitution that's suffrage and eligibility to office, and trying to figure out if that provision can be used not only to say you're not eligible to run for that office, but if you're currently in the office, we're going to kick you out of it. And that, so like, I guess my question is, could you answer my hypothetical? If these cases remain, Chastain 1 and Chastain 2, could a trial court somewhere in our state adjudge the governor guilty of corruption and malpractice and remove him from office although he had not been impeached?
No, Justice Dietz, because of what you've raised with Mr. Ballou, which is we already have the procedure. Article 6 does not have a procedure. Article 6 just lists who cannot serve in an office. So we have to look elsewhere for the procedure. Here, we have a statute that the General Assembly has enacted that gives us the procedure. We have the same thing in 7A-66 for district attorneys. We have the same thing in 7A-133 for magistrates. In Ray Peoples said the General Assembly had the authority to enact a statute for judges.
Okay, so let me change my hypothetical. The General Assembly has enacted a statute that says the process for adjudging the governor disqualified from office under Article 6 is this, and you follow that statutory provision. That's not the question I'm asking. The question I'm asking is disqualification from office under Article 6 also removal if you're the current occupant of that office? And the reason I'm asking you that is, if that's true, it will override the provision in the Constitution that already says there's only one way to remove the governor, and that's impeachment.
So, if I'm understanding correctly, and correct me if I'm wrong, so if the General Assembly attempted to override a specific procedure laid out in the Constitution, that would not be valid. The Constitution
What I'm saying is there is no procedure currently in any statute about how being a judge guilty of corruption or malpractice occurs. So suppose that the legislature said, well, you can bring a civil action if you think a public official is committing corruption or malpractice in office, and there's a bunch of process provided there to make that adjudication. That happens with respect to the governor or any other official where the removal is spelled out expressly in a provision of the Constitution. If you then adjudge them those things, and therefore they're disqualified from office, I'm just trying to figure out if your position is by operation of law then, if they're currently in the office, they're also removed.
So to answer that specific question, our position is yes. If you are disqualified from serving in an office, you cannot be serving in that office, even if you had previously been elected to serve in that office.
But doesn't that mean then that if the General Assembly was refusing to impeach the governor for some reason, most likely because they don't have the votes, that the court system could adjudge the governor guilty of corruption and malpractice under Article 6, because the text there is very clear. You just need the adjudication. And then the governor would nevertheless be removed from office. And doesn't that seem inconsistent with what the framers intended there?
That could only be the case if there's not a procedure already in place. So you're right, there are a lot of offices in this state, some of them have not been addressed by specific statute. So for those, if I can change your hypo slightly, for those offices where we don't have a procedure, then yes, that's an unanswered question. How would somebody go about doing that? I think it would be a civil action, and it may go back to the quorum issue that you raised, Justice Dietz, of if we don't have something on the books, then we look to the common law. So that would be...
to me seems inconsistent with what the framers meant. It seems to me that the reason they put that provision in the section that's about suffrage, about voting, is they're saying this is your eligibility to office, meaning your eligibility to be a candidate and get elected to that position. And if you've been disqualified, you cannot be one of the people that tries to run and then be certified as the winner of the election and take office. But if you're in that office, the Constitution, the structure of our Constitution, spells out other means of removing the current occupant from office, because when they took office, they were eligible for that office under Article 6.
So, a couple of things, Justice Dietz. So, I agree, Article 6, the default is anyone in this state is eligible to serve in office. Article 6, Section 8 limits that to certain individuals who are no longer eligible. So the default is you can run for any office, that's how our system works, unless some exception applies. Those exceptions are listed in the Constitution. Other provisions of the Constitution talk about specific offices. For example, Article 4, Section 17 talks about judges and says judges can be removed in accordance with statutes presented by the General Assembly. The General Assembly then gave that authority to this court in conjunction with the Judicial Standards Commission. So the General Assembly has enacted a procedure of what that looks like. The same thing they've done with clerks and with district attorneys and magistrates. That doesn't, I would respectfully disagree that conflicts with Article 6, Because
But
again,
I think I'm still going in the opposite direction. I'm not sure you're tracking me. So, for example, take the other provisions in Article 6. If the governor is charged with a crime and refuses to resign, goes to trial, refuses to resign, is convicted of a felony, refuses to resign, doesn't the legislature still have to impeach the governor?
if I understood,
Or would a court just order, well, you got convicted of a felony, and this says you're not eligible for office, so you're done, you're out?
I believe that's the plain language of Article 6 says, if you have been adjudged guilty of treason or a felony, then
Not
the
eligible
following
for
person shall
office.
be disqualified.
Right, you're disqualified
For
from
office.
office. But the section that describes the powers and duties of the governor makes it very clear that once you're in that office, the only way you're out is the General Assembly impeaches you.
Well, I guess you would have to read those provisions in tandem, and so I guess I would disagree that that's the only route. If Article 6 is to have meaning, and it, by its plain language, says if you've been adjudged guilty of these certain things, you are disqualified for office.
Yeah, I mean, I understand your point, but I'm just wondering if you see the mischief that I see, if you were right about that, which is that it's giving the courts tremendous power to adjudicate people guilty of corruption or malpractice, which, as this case points out, is an awfully murky standard, and then
Definitely.
start removing elected officials from office when the framers said, this is how you will remove this person, and for whatever reason, that procedure is not being used.
So a few things to that point, Justice Dietz, because I do think that's important because Ms. Chastain has presented this, slippery slope argument. So there are a few things. The General Assembly obviously cannot trump the Constitution, but it can enlarge or specify rights that are already laid out in the Constitution. So the General Assembly could enact specific statutes on what this means or how it could be accomplished. Of course, we also have the burden of proof issue, which is clear and convincing evidence. That's what we adopted at trial. That's what Ms. Chastain agreed to. So it's not as if a judge could willy-nilly, just sign a paper that says somebody is disqualified for office. There's also the normal due process rights to cross-examination and all of those things, the right to present evidence. So again, what's being contemplated is a full and fair trial, which Ms. Chastain received in this case, but I understand we're looking at other potential cases. All of those rights would still be in place, and of course, the right to appellate review. But here, again, the reason I started my argument the way I did is I don't think the court has to get to any of these questions. If the court agrees that Judge Locke could hear the matter under Article 4 and Section 7A105, then there's no need to address those issues.
Well, Counselor, I do have a question for you with regard to that. How do you address the mootness argument that your friend is making?
Well, that's only true if removal means limited to this term. So if the court interprets removal to be current term, then that's correct. Her term would have ended regardless. There's already been a new clerk elected, so that issue would be moot. But everyone's understanding all along was that removal, and I don't see anything in the statute or the Constitution to say otherwise, removal includes permanent removal from this specific office, which is different than disqualified from serving in any office, Justice Berger, right? That's a different issue. That's a harsher sanction under Article 6. But Article 4 talks about removal from this office, which is what Judge Locke did here in his original 2020 order.
And I'm sorry I keep capitalizing on your argument time, but isn't the other point too that, I mean, if you play this out, the reason it's not moot is a judgment here that this was all erroneous for Chastain would potentially allow Chastain to pursue a quorum claim or something and say, you owe me some pension money and a back pay and all kinds of things like that.
That is certainly, I mean, she's never brought a claim or alleged anything about retirement benefits other than in brief to this court. But yes, there are potential collateral consequences. And of course, as I believe Justice Earls mentioned, if the opinion on the books is left to stand, then there's an issue going forward and whether that is in fact the law of North Carolina or not. So what we're asking this court to do is uphold and affirm Judge Locke's 2020 order that permanently removed Ms. Chastain from office under Section 7A105 and Article 4.
On the subject of Judge Locke's order, there's some wording in there where Judge Locke doesn't specifically find malpractice or misconduct. He says that the conduct is essentially equivalent to. Should we be concerned with the lack of a specific finding?
Not at all, Justice Berger, for a couple of reasons. First, the the things that he thought were corruption and malpractice in office, I believe he said they constitute corruption or malpractice in office. So I believe, at least for several of them, he did find specifically that they constitute equal or corruption or malpractice in office. There were things that he said did not rise to that level, which, he made findings about them, but those weren't a basis for his decision. But the other thing here is he made 4 independent analyses on Ms. Chastain's conduct and said each of those individually constitutes corruption or malpractice in office, and that the cumulative effect of her conduct also constitutes corruption or malpractice in office. So in order to give a win to Ms. Chastain, in order for her to prevail, this court would have to disagree with all 5 of those conclusions. So regardless of how the court might feel about 1 or 2 of them, in order to reverse, it would have to be on all 5, because at least according to Judge Locke, all 5 of those were independent bases for disqualification under Article 6. And I'm not sure if you're referring to, there are 2 orders in this case, right? There's the 2020 order and then the 2022 order. So obviously the language is different in those because of the procedural history. So I wasn't sure which order you were referring to. The first order obviously did not talk about corruption or malpractice at all because that issue was not on the table. The second order from 2022 did talk about.
No, I'm sorry, I was inartful in corruption and malpractice.
I would never say you're in.
Well,
Justice Berger.
Yeah, you wouldn't be the only one who did.
So let's say that we believe Judge Locke properly could be substituted by the Chief Justice for Judge Dunlop under Article 4. Is Judge Locke's order, the language in the order, sufficient to support an adjudication that complies with Article 4, or because of this knot that the Court of Appeals rulings got themselves into with Article 6, is there a risk that they were using the wrong legal standard?
So if I'm understanding the question, if the court were to say Judge Locke could hear the matter.
Right, not because of the Article 6 theory the Court of Appeals had, but because he was substituted to take over for the senior resident who could not hear the case.
Then yes, we would say his 2020 order has sufficient findings supported by evidence in the record and sufficient conclusions leading to his result of removal from office.
The component of, let's say, willfulness that needs to be in there is in there.
Definitely. And willfulness, of course, is a question of fact. I mean, that's the other problem. Of course, I was a little surprised by the argument made today because it's very different than what was presented in the briefs. The case came to the court based on a dissenting opinion from the Court of Appeals. The main problem with the dissenting opinion from Judge April Wood was that it was written as if she were finding facts in the first instance. That's not the role of the appellate court. It went on appeal solely to decide whether there were sufficient matters in the record that could support the findings and whether the findings supported the conclusion. So that was a long way of answering, yes, Justice Dietz, we believe this court can affirm and uphold the 2020 order from Judge Locke based under Section 7A-105 and Article 4.
One more quick thing, and then I'll stop pestering you, but just to be clear, we allowed a PDR on additional issues in this case, right?
Yes.
Yes.
And
including the question that many of us have been struggling with, which is what constitutional provision here are we dealing with?
correct. That was, and we offered that to the court because we think it will help to provide law going forward. For those reasons, we would ask that you affirm. Thank you.
Thank you, counsel. Rebuttal.
Thank you. In my very limited time, my colleague said that Article 4 doesn't say shall for the Superior Court judge, but also agrees that the General Assembly can enlarge or lay out the rights in the Constitution. 7A-105 does say shall. 7A-105 says the senior resident shall preside over the removal hearing. Thank you, Your Honors.
Thank you, counsel. Mr. Clark.